So Ms. Bossell, we went,
Yes, sir. I saw that.
Mr. LaPel, we
No
went and
objection,
signed.
thank you.
Thank you. Okay. We'll begin with our afternoon with the pleas. Just a preliminary remark. The purpose of this portion of today's hearings is called an arraignment. The purpose is to make a plea. Guilty, not guilty, no contest. So there are a number of you who are here today who don't have an attorney, and therefore you've not, I presume, gotten legal advice. And so if you are here today without an attorney, the first thing I'm going to do is ask you whether you want to have an attorney appointed or whether you're going to hire a private attorney. In some circumstances, if there's not an incarcerative sentence, you might enter into some type of a plea, if you wish, with the state. And that may be offered to you as well. But if there's any type of incarceration involved, I will be asking you whether you have an attorney, appoint you an attorney. Obviously, you still have to apply for it and go through the paperwork. But I'll appoint you an attorney for today and enter a not guilty on your behalf so that you have a chance to meet with your attorney before you give up any rights. That's the key. My job is not to play favorites, but to make sure the rights of both parties are protected. So you need to talk to your attorney before taking any action unless, for the most part, I'll just leave it at that. So, do you want to try and do the, you want to do that? Okay. Let's go ahead with Rodriguez Alvarez.
Rodriguez Alvarez.
Alvarez Rodriguez Kenneth.
State.
Your Honor, asking for KP.
Court will issue a no bond cases. The interpreter, who are you here for?
I am here to assist Mr. Medina and Mr. Gates with Andrade Lainez. That's Mr. Medina.
Hold on a second. Let me go to that. Wait, what's the first one?
Andrade.
Yes, who's?
Mr. Medina.
Mr. Medina's, Your Honor.
As for the last case, there's no information on the case for Mr. Kenneth Alvarez Rodriguez.
That is a fugitive from justice case. So
should we issue KPs? Because if it's a fugitive from justice case, he might have been transported to where he went, which is why he's not in court.
Well, let me find it first, because I'm not.
I'm just now realizing putting the
What
pieces
number
together.
is Mr. Left?
I was looking at
It should be under the A's, A-N-G-R-A-D-E is the last name.
Andrade?
Yes, sir. That's a young lady.
That's Mr. Medina's case.
Yes, sir.
for Alvarez.
Mr. Medina here?
Yeah, I believe for the attorney's
Okay. Is he talking with Andrade?
No, he's not. He's talking with inmates, Your Honor, and it looks like Andrade's out of custody.
That's
Is
correct.
Andrade here?
Andrade Lainez is here, yes, Your Honor. He's the female.
I can send my partner to a meeting where I can go to retrieve.
Let's go. Yeah, let's bring him.
I am not going to be
What is yours? Which one is yours, Mr. Gates?
I have two. I have, I'm going to let Madam Interpreter, otherwise I'll butcher their names. There's Lida Gaitin.
No, I have Garcia Bravo, Oscar, And I observed that Linus, she retained Mr. Garrett. Yes.
So number 33 and 34, Garcia and Gaetan.
Yes, Your Honor, it sounds like Ms. Guyton retained Mr. Christopher Garrett, and if that's the case, I'll call the written plea not guilty.
Has that been filed?
Would the
Okay,
court
so-
relieve the public defender's office?
Gaetan is not guilty, written plea, so we don't have to worry about that.
And would the court relieve the public defender's office on that?
You're right.
We took the not guilty plea and put Mr.
And then Garcia Prado,
He is present, Your Honor.
he present, he
Yes,
can come
sir.
forward.
Garcia Bravo, venga, por favor.
Then Mr. Medina, we're trying to get the interpreter cases out of the way.
That's fine, Your Honor.
Would the state go ahead and announce?
I don't know if the state, because you will, the interpreter.
Each please raise your hand. We can go
Do
straight.
you agree I actively interpret the English and Spanish and English matters are on those days?
I do.
And there's no information on this case.
The name again, ma'am?
Garcia Bravo.
Oh, Garcia Prado is mine, Your Honor, I apologize.
And the clerk informed me that an information has not been filed.
Your Honor, there should be an order pending for you. My understanding is that there was an order to transfer down to county court. Upon noticing that the case had not been transferred down, I followed up with my legal assistant and ensured that we get an order, a proposed order to Your Honor to transfer this down to county court today.
Okay. Obviously, I haven't seen it,
Of course.
but I generally will sign it. I'll look for it when I get back. If you want to follow up with my office.
I saw it as well this morning, Your Honor. I received an email with that attached.
So, Senor Garcia, this case is not in the proper court. This is a felony court, more serious crimes. Your charges are in the misdemeanor court with the county judge. So we need to transfer that down, and then you will, do we know when the next hearing is for the county court?
No service, I don't want to do this initiation. If we could just verify his address, he'll be more than notice. Unless it's in the children. And if that information has been delivered to the public defender in county court this morning, seeing as he doesn't, Mr. Gates.
I would say let's bring him back as a status, but wait his appearance next Tuesday to make sure all the T's and crossed and I's dotted.
Don't have a problem with that. So hopefully we'll get everything transferred, but if you don't get verification through your attorney that the case has been transferred, we'll come back here 1 week from today at 2:30, excuse me, at 1:30 to continue this hearing and make sure we get that transferred properly.
And can we get his address from that clerk just to verify?
I've got 1341 Jackson Avenue in Chipley, in Florida.
I moved, so right now it's 5 Old Courthouse Way, Unit
This way we can ensure he gets the proper notice,
Absolutely.
given that he lives in Tallahassee, it's about an hour and a half drive and an 8-turn drive. And also, PJ, did you still have the QR stuff? Where you can scan to see the status of the case?
We don't have that here now, but you can go to the Okaloosa clerk's online. Oh, no, that's asked.
Why don't we have that now?
Thank you, Your Honor. She'll set a meeting and with an interpreter, we'll see the court on February 14th. Thank you.
Very good,
Ms.
thank you.
Medina?
TJ, do you want to go through the other?
Yeah, I figured we'd do, like we do all the out of custody that we can do, and then start doing the things.
Mr. Medina, you want to do yours, or you want to wait? You're going to do out of custody first?
I've been trying to deal with in custody, and I haven't talked to out of custody, Your Honor, but we can do
Okay,
whatever.
well, let's pass over Mr. Medina's, and we'll just go, let's start with the no attorneys, and then we'll do, or do you want to do yours first, Mr.
Yeah,
Medina?
I've only got one out of custody left on the docket. That should take 2 seconds.
Let's do that, and then we'll do the no attorneys.
If we do the no attorneys, I know Mr. Medina's got potential, so that's.
He's
You got Robert Hoff.
That is what I have, Your Honor.
Okay.
Thank you, sir.
Thank you very much.
Mr. Hoff should be number 38 on the docket, I do believe.
Okay, thank you.
Your Honor, this is Mr. Hoff before the court. I intended to file a written plea not guilty on this case. However, after reviewing discovery, I noticed that there was a HFO notice filed in discovery. In an abundance of caution, I wanted to keep it on the docket so that the state could file that for record.
Your Honor, the record can reflect that I've provided an HFO notice to counsel for Mr. Hoffman.
Okay.
And I provided that to my client, Your Honor.
Very good.
At this time, if we can enter a not guilty plea for Mr. Hoff.
The court will enter a not guilty plea, and we'll come back for our pretrial on February 13th at 9 a.m.
Thank you, Your Honor.
Okay, we'll do the defendants without attorneys. Courtney Baggett. Would the state announce, please, while he's coming up?
Yes, Your Honor.
Come to the podium.
This is 22 CF 2940, Your Honor. And I do have an offer from Mr. Baggett.
Okay.
You would like them to hear it?
Yes.
So the state's offer for a plea today would be plea as charged to count 3, which is the possession of drug paraphernalia misdemeanor count. In exchange for a plea to that count, the state would dismiss the felony counts in counts 1, and the other misdemeanor possession. Oh, I'm sorry, the count 2 is a felony count. The state would dismiss count 1 and count 2. And count 3 would ask for 11 months, 29 days of probation, for him to pay the misdemeanor court cost, for him to have a substance abuse evaluation within 30 days, and begin treatment within 60, for him to do 24 hours of community service, for him to maintain gainful employment or complete 2 job applications per week, for him to surrender all firearms to the Okaloosa County Sheriff's Office, and for him to not trespass at the place that this offense occurred.
So, Mr. Baggett, you've had an offer. You may need some time to digest that offer. The offer will remain open for at least a little bit period of time. If you wish to have an attorney appointed, I can appoint an attorney, enter a not guilty, and you can come back and review it, or you can take whatever action you want here today if you wish to accept that offer, but you may not want to.
I would like an attorney.
Okay. So the court will appoint the public defender, and the court's going to issue a not guilty plea. and we'll come back on 2/13, February 13th, at 9 a.m. for pretrial. And again, if your attorney, you all end up, the plea agreement will still be on the table if you want.
And Your Honor, for, just to put it on the record, my understanding is that this is a provisional appointment at this time until he complete the application for criminal indigent status and it's approved by the clerk. It's provisional. So I'm giving him my court card with Vicki, my assistant's name, to set an appointment, but you need to, before you leave the court, get that completed and turned into the clerk. Thank you.
Point well taken, and folks that are going to be getting appointed should listen up to what Mr. Medina just said, because everyone's got to do that. Question?
Yes, sir. Oh, go ahead. Who would I turn this into?
The clerk downstairs.
The clerk downstairs. Okay, thank you.
Thank you.
Caleb Beeman. Caleb Beeman. State.
Your Honor, the state's requesting papers.
Beeman.
Oh,
Okay, it was a not guilty plea filed by Michael Gilbert
Okay, very good.
today.
That would be why I didn't,
Okay,
did that occur?
very good. So no KPs. Okay. Ricardo, thank you. Ricardo Botzik. That's okay. We'll skip over that one. Noah Brennan. State announce, please.
Honor. This is 22 CF 2974, Your Honor.
And Mr. Brennan, you do have a right to an attorney with this new charge. You wish to have an attorney appointed. You're going to hire private counsel.
I'm going to hire one, sir.
You're going to hire private counsel?
Yes, sir.
Okay. Court's going to enter a not guilty plea in your behalf, so you have a chance to meet with your attorney. We're going to come back on 2/13, February 13th at 9 a.m. for pretrial. Make sure and be there. Try and meet up, get your attorney in place before then, okay?
Thank you, Your Honor.
Okay. Gregory Brooks. The state announce, please.
Yes, Your Honor, this is 22 CF 3010. Your Honor, I don't think that there was information filed in this case. I know I didn't generate one. And the reason for that is that I am supposed to get a certified copy of his driving history to confirm the habitual traffic offender status. That should be coming in tomorrow. So if we can place him on next week's arraignment docket, I will have an information file and I will have an offer.
Very good. We'll continue this until 1/17 next Tuesday at 1:30 p.m. Okay?
Right down the collar.
Sure.
Oh, yeah, median, but there's some pencil.
Okay.
You said 117?
Yes, sir. Next Tuesday.
$130?
1:30, yes, sir. De Benedetto, Carissa. The state announce.
Yes, Your Honor. This is 22 CF 3092, Your Honor. And I do have an offer for Ms. De Benedetto, but it includes drug offender probation as well as followed by a lengthy term of probation.
Okay, so why don't we do this? The offer it'll still be out there for a little while. So you do have a right to an attorney. You wish to have an attorney appointed, you're going to hire private counsel.
I'm not gonna, I'm ready to play.
Okay. Court will appoint the public defender, but you, as Mr. Bedino mentioned, you have to file the proper form, so this is provisional. I'm going to appoint the public defender. Go ahead and enter a not guilty plea so you have a chance to meet with your public defender or your attorney and come back for pretrial on February 13th at 9 a.m. Okay?
Don't talk about your case now. Thank you. Thank you, Your Honor.
Thank you.
Will you excuse Your Honor? Thank you.
Tammy Dixon. What number, what page? What page? What?
I don't have a copy of the docket, I only have the C's. I've got Cox, Crandall, Cochran, Cornelius.
Oh, yeah, I do have, you're right, Cornelius is one. That's somehow it's completed on it. Yeah. All I've got is Cornelius that don't have an attorney that are unrepresented. Yeah. So we'll do that one in a second. Would the state announce for Ms. Dixon, please?
Yes, Your Honor. This is 22 CF 3093. And at this time, the offer on this case is to adjudicate Ms. Dixon guilty and for the court to impose 8 months in the Okaloosa County Jail, the court cost.
Okay, let me make a suggestion. I'm going to go ahead and offer you an attorney so you can discuss it with the attorney before you accept the plea.
Okay.
You wish to have an attorney appointed? Yes. Yes.
I'm sorry, I'm a little hard to hear.
Do you want to have an attorney appointed?
Yes.
Yes. Court will appoint the public defender. You need to fill out the proper form, but the court will enter a not guilty plea. Meet up with your attorney so he can go over the plea with you and figure out where everything is at, and we'll come back on 2/13 at 9 a.m. Okay?
Thank you.
February 13th.
So make sure you turn that in.
Joshua Cornelius.
First one, please.
Joshua Cornelius. State.
Your Honor, state requesting a capias.
Court will issue a no bond capias. Edmund Foster. Edmund. It's an inmate?
Yes.
Okay. Doesn't have it online. Okay, so those are all the non-inmates that don't have attorneys. How do you want?
If you want to, however you want to start inmates, we can. If you want to start with the out of custody,
You don't have your
attorneys.
custody, right?
Well, no, but I thought there was one.
Let's just start going down to the ones that have attorneys.
I show a few others in my part of the alphabet that don't have attorneys.
Okay, why don't you, hold on, okay.
37, 39, 42, 33.
37. Yeah, you're right. 37, Jerome Hatton.
Inmate, I showed him the name.
He's an inmate. Okay, and then, Lauren Howard. I don't know how I missed it. Give me a piece of paper. State?
Yes, sir. Your Honor, this is case 22 CF 2956. The allegation in this case is one count of possession of controlled substance. State's offer to Ms. Howard is a plea to a lesser included offense, possession of marijuana less than 20 grams, and court costs in the amount of $615.
Ms. Howard, is that something you'd be interested in, or you wish to have an attorney appointed and try and consult with your attorney before you take any offer? You're welcome to do that. The offer will remain. It's not going to go away.
I'll have to apply for an attorney.
Okay. The court will appoint the public defender. The court's going to enter a not guilty plea. We'll come back on 2/13 at 9 a.m. for pretrial. Try and meet up with your attorney in the interim, okay, man?
And Your Honor, could
Hold on.
I just
Hold
want
on,
to
man.
confirm the offer before Ms. Howard walks away. I have it, but I want to make sure I'm reading it right.
Okay.
Withhold of adjudication, possession of marijuana less than 20 grams, court costs.
So
That's a lesser included.
essentially misdemeanor and court costs of about $270 today, no probation, nothing else,
Just basically a fine.
basically.
That's fine.
I had a feeling that might go that way, Your Honor, given that it's a withhold court cost and probation. If the court lets her do that, they'll save $150.
Okay, so the court's not going to appoint a public defender. Do we need to paper this?
If the court doesn't think it's necessary, I don't believe it is, Your Honor. I'd be happy to read it out. The statute at issue is 893.13 sub 6 sub B, possession of marijuana less than 20 grams. It is withhold of adjudication. Court cost would be $615. Well, initially they may not be for $270. Thanks, Travis.
Ms. Howard, I'm going to ask you to swear just for a second. Let me ask you a couple questions. If you raise your right hand, do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
A lot of people are shouting, talking and whatnot. I want to make sure, you can put your hand down. I want to make sure two things. One, you understand what the plea is that you're being offered, and that you understand what it is. If you have any questions, they can be answered, okay? So, and you want to make sure that if you accept it, your acceptance is free and voluntary, okay? So, you heard the attorney for the state attorney, state the terms of the offer, okay? For a lesser included, so withhold, which is good for you rather than adjudication of guilt. To a lesser included possession of marijuana, less than 20 grams. That's a misdemeanor. Significantly different than a felony, which is what you're charged with. The fees for that are $270. So, you're doing a withhold of adjudication, fees, that's it. That's all you're getting here. So you're not serving any probation, not serving any time in jail on this offense. This first offense, but it is going to be on your record. Do you understand that?
Yes, sir.
Do you feel like you need to talk with an attorney before you accept this, or are you willing? I don't want you just to feel like you're rushed into this. This plea will stay out there. Nobody's going to take it away from you if you don't speak it to them. Okay? I'm always a little concerned that people don't know exactly what they're doing. They feel like they're being railroaded. Obviously it's a good offer, but I still don't want you to feel railroaded. Okay? Do you want to take this offer here today?
Yes, sir.
Okay. You understand this will be a final resolution in your case. You don't have to come back for any court hearings. Okay? And you feel like you understand it enough to enter into this plea?
Yes, sir.
Okay. Very good. Court will accept your evidence, the testimony, and accept the plea, and the court will enter a withhold of adjudication on the lesser included charge of possession of marijuana, less than 20 grams, to pay the fees and court costs. And we'll have, what do you say, 180 days to pay those? Or it goes to collections?
State is fine with that, Your Honor.
Okay, you gotta pay it, set up the payment plan, if you can't do it all at once. And send a little bit each month, but check with the clerk, to set up that payment plan, okay? Thank you very much. Okay. Don't know why I skipped over these. Jason Junkins. State.
Sir. Your Honor, this is case 22 CF 2948. The information in this case charges one count of driving while license revoked pursuant to habitual offender. The state is not willing to make an offer today that was suspected narcotics collected in the course of the search. I've inquired with Florida Highway Patrol about whether those suspected narcotics have been submitted to FDLE.
Okay, so we do have to make a plea here today, Mr. Junkins. You do have a right to an attorney with this charge. You wish to have an attorney appointed, or you're going to hire private counsel?
We're in the process of hiring a private counsel.
Okay, so the court will enter a not guilty plea on your behalf. We'll come back on 2/13, February 13th at 9 a.m. for pretrial. So between now and then, get up with your attorney. You both need to be there on February 13th at 9 a.m.
Yes, sir.
Okay?
Yes, sir.
Thank you. Michael Krupp.
Judge, this is case 22 CF 3022. The state has charged one count, possession of a controlled substance. State's offer today is a plea to possession of marijuana less than 20 grams, an adjudication of guilt, and $270 in court costs.
So, Mr. Krupp, like I said to you before, this offer's out there. It won't go away today. If you feel like you need to talk with an attorney, we can enter a plea, talk with an attorney, either hire an attorney, have one appointed. How do you wish to proceed today?
I have one question.
Okay. I'll answer it if I can.
I have acquired my prescription for what this is. If I take this plea today,
Okay.
will that affect that?
Okay, so what I would suggest you do on that, let's not take the plea. Let me appoint you an attorney today. Talk it over with your attorney. Okay, that's a question I shouldn't be answering. So I'm going to appoint you a public defender. You still got to fill out the form.
Yes, sir.
And I'm going to enter a not guilty plea on your behalf, okay?
Yes, sir.
And we'll come back for pretrial on 2/13.
Yes, sir. Thank you.
Okay? Try and be in touch with your attorney in the interim.
If Mr. Crook can have his seat and fill some information out for me, and I might be able to talk to the state briefly about the resolution, depending on what they want to do if they have time. If not, he's already got another court date.
That's good. Now, Mr. Gates, I think that's all that I've got on here. This should have gone. I don't know what.
I saw that.
This was like, too much of a rush to get through it.
My assumption was either they're hired or we missed, and I didn't want to assume they either way on that one.
Okay. So, what?
I have Kyle Fitzwater.
I think we
Didn't we do that in this hearing?
Didn't we do that one?
Your Honor, I have a couple of out of custody that I did talk to.
Okay.
May I call Colby L. Cochran? Mr. Cochran is approaching in 22 CF 3060. My understanding is we're probably just going to need to enter a plea of not guilty today. I did want to make sure I understood the state's offer, which is an 18-month probation offer with substance abuse evaluation treatment, 24 hours of community service, and then there was an automatic early termination. Was that upon completion of the 90-day mental health court program that he's in, plus the substance abuse evaluation and other requirements? Okay, so, Your Honor, that may be what he wants to do, but right now we want to just enter a plea of not guilty so he and I can meet. And did I give you my card? I will.
And we'll come back on 2/13, February 13th at 9 a.m. for pre-trial. You'll be meeting up with your attorney in the interim and
Yes, sir.
see if they're going to be arrested.
Can you have an application? Absolutely. I'm sorry, I thought you were already recording on the first floor. Yeah, you can fill it out.
What's the next one, Mr. Medina?
Thank you.
Patrick K. Dougherty, D-O-U-G-H-E-R-T-Y. Dougherty. Dougherty, thank you. Your Honor, Mr. Dougherty is before the court in 22 CF 2969 and 22 CF 2970. And at this time, Mr. Dougherty is going to plead not guilty in both cases. And we'll leave this set on February 13th if it's okay with the court.
Very good. We'll enter a not guilty plea, come back on February 13th at 9 a.m. for pre-trial.
Thank you, Your Honor.
Thank you. So you want to do some, Mr. Gates, you want to do some?
We can, Your Honor, if the court wants to do the in custody.
I have females lined up, ready to go. if you'd like.
You want to, okay, let's do the inmates. We'll do the female inmates.
Yep.
Start with Virginia Brake.
Virginia Brake to the left.
Come on, Your Honor, please. Your Honor, I obtained some information that I wasn't able to relay to Ms. Brake. May I just have a moment?
Sure.
Your Honor, Virginia Brake is before the court in 22 CF 2972. I emailed the state this morning after I received an email from Ms. Sharpless. I believe, am I understanding correctly that the state's position is 11 months, 29 days jail, or was it probation?
It's jail.
Okay, that's what the way I read it. So at this time, Ms. Brake would like to enter a plea of not guilty so that she and I can meet to discuss this further. She was prepared to do a misdemeanor probation deal in order to put the case to rest, but it doesn't sound like the state's willing to do that today. So
Very good. The court will enter a not guilty plea and we'll come back for pre-trial on February 13th at 9 a.m. You'll meet with your attorney.
Your Honor, because she's in custody, unless she's out of custody, we probably need to put her on February 15th. Is that correct?
That is correct. Thank you very much.
Thank you.
Putting him on the wrong number too.
Tracy Polk.
This is Ms. Tracy Holt before the court. Your Honor, this vote should be number 31 on the docket.
I can ask for me to keep,
What's the number again?
Your Honor, I have number 31.
Okay.
Your Honor, we have a plea hearing to file in Ms. Folt's case. The plea as charged, she was adjudicated guilty. Counts 1 and 2 are going to be 45 days time in jail with credit for all time served. That is concurrent. No probation to follow. $615 court costs, $150 defender fee. Ms. Folk would ask for 24 months to pay those outstanding costs. May I have a vote, Your Honor?
State the agreement.
This state's agreement, Your Honor.
Ms. Foltz, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
Okay, you heard the terms of the plea agreement, Ms. Foltz, and I see that those same terms are contained in the written plea agreement that I have before me that you've signed. Have you read through this plea agreement closely and gone over it with your attorney?
Yes, sir.
Feel like you've gotten all your legal questions answered? You understand that by entering into this plea, you're waiving the right to go to a trial. This will be a final adjudication of these charges. Do you understand that? Is that what you want to do here today?
Yes, sir.
You believe it's in your best interest to enter into this plea agreement? Nobody threatened or forced you to get you to enter into this? Do you have any further questions regarding this agreement?
No, sir. I don't believe so.
Okay. Based upon that, the court will accept your plea agreement. There'll be an adjudication of guilt on both counts 1 and 2. The court will sentence you here today to 45 days in the county jail to be served. I'm assuming this is concurrent.
Yes, Your Honor, I announced it as concurrent.
Okay, it's not in your plea agreement, it's concurrent. That's what's stopping me here.
Yes, Your Honor, I can make that notation if the
make
court
that.
would like.
So it'll be 45 days concurrent, so run together, not stacked on top of one another.
Okay. Yes, sir. I appreciate you.
That's all right. We just want to make sure everything's clear.
Yes, sir.
And you'll have no probation to follow that. There's fees and costs that are contained in the plea agreement. You'll have 24 months from your release to pay the fees, and if not, it'll go to collections. Okay? Any questions?
No, sir.
Okay. And you okay with the score sheet, Mr. Gates?
Yes, Your Honor.
Thank you very much.
Thank you.
Your Honor, next should be Yashika Jones. This should be number 41 on the docket. Very good. We have a plea agreement to be filed in Ms. Jones' case, Your Honor. There'll be a plea as charged in both cases. 22 CF 2595 and 22 CF 2987 shall be adjudicated guilty. And 22 CF 2595, 24 months of probation concurrent. Waive costs of supervision, $515 court costs, $150 defender fee. The restitution is set in the amount of $1,050 to Miss Juana Gamble at 25 Pohan Drive, Fort Walton Beach, Florida. The state has agreed to take no action on the FDA associated with that case. In 22 CF 2987, 24 months of probation concurrent, waive costs of supervision fee,
$515 in court costs, $100 for the defender fee, must be anti-theft course, and there's a cost of transportation in the amount of $282.13 to the Okaloosa County Sheriff's Office.
See, agreement, Your Honor. You will see on the score sheet that Ms. Jones does score prison. This agreement is based on a which event uncoerced plea agreement.
Thank you.
No objection to the score sheet, Your Honor.
Thank you very much. So, Ms. Jones, just need to ask you a few questions to make sure you understand what you're doing here today and that you're entering into this freely and voluntarily, okay?
Yes, sir.
Would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Now, you heard your attorney state the terms of your plea agreement.
Yes, sir.
And I see, put your hand up. You can put your hand up. And you also, I see that the same plea agreement is contained in your written plea and sentencing agreement that you signed.
Yes, sir.
Have you gone over this? Have one of you read it?
Yes,
Have you
sir.
gone over it closely with your attorney? Make sure you had all your legal questions answered about this plea agreement.
Yes, sir, I have.
Because you're waiving some valuable legal rights, as you're probably aware. The right to go to a trial, to force the state to prove their case, etc. You're waiving those, there'll be a final resolution in your case here today.
Yes, sir.
And you believe that's in your best interest?
Yes, sir.
Nobody threatened or coerced you to get you to enter into this plea?
No, sir, no like that.
Okay. And you're satisfied with your legal representation?
Yes, sir, I am.
Okay. Very good. Based upon that testimony, the court will accept your plea agreement, and on both cases, the court will sentence you to 24 months of probation. They will be served concurrently, so a total of 24 months, plus a number of court fees and costs that are contained in the plea agreement. In addition, there's restitution, the amount of $1,050 to Ms. Gamble, and the address associated with it, and no failure to appear will be acted upon by the state. It's outstanding. Okay?
Okay, yes, sir.
Very good. Thank you very much.
Is it in person or is she taking it from the court?
For the court, Your Honor.
Your 50 feet when she comes in to pay. I'll give the information in the case.
And the probation is asked if Ms. Jones can provide her address.
I'm sorry, restitutions to be paid through the court or through probation?
However, we normally do it through probation is what I thought.
Through probation.
Okay, I just wanted to make sure.
29 Florida Bunker Place.
2940
Florida Bunker.
Florida Bunker. You know what I mean? City is
4 Florida.
Take your honor.
Chris Brown referenced the extradition from this morning. Mr. Brown, go ahead towards the record.
Steve Medina with Christopher J. Brown, 22 CF 2666. I don't know if the state has had a chance to consider the motion to discharge him from jail.
And your Honor, the state did, and the state does agree within 90 days or almost up. We would just ask that this case be left on the docket, and so that we can have a status on whether governor's warrant is done.
I'm not following you. Mr. Medina said that the time period has expired. You're saying it's close to expiring. What is the state's position? Is it, Mr. Medina, that the time has expired? Is that your belief?
Our position is yes. There is a caveat I wish to clarify for the court, and I think that's what the state is referring to. There's an initial, as I understand it, there's an initial 30-day period. That's subject to extension for a maximum of 60 additional days. My understanding is that the 30 days expired without a 60-day or other extension being granted. But assuming there were a 60-day extension had been granted, I think it would expire in a day or two. So there would be maybe a day or two more. But I don't think he is properly in jail at this time because of the initial 30-day period. So that's my position on behalf of him. Today, he's saying is the 90th day. I just don't have it exactly what the 90 days is, but it's within a day or two of today, if it's not today. Okay. I knew it was right around today. But, Your Honor, I think it's one where the governor, I know nothing about Oklahoma law, but the governor there and then the governor here have to do things.
I understand, but let me see where the state's.
Your Honor, what's going on? So the 90 days is essentially up. We're at about 87 days.
It would be July 13th, I think. Would be 90 days.
January
I said
13th
July.
would be 90 days. He does need to be released. So that's the state position. However, that does not mean that the FFJ case is simply dismissed. It needs to remain on the court's docket with notice such that the state can then inform the court about whether a governor's warrant has come back at that time. So agreed. The defendant does need to be released based upon the passing of the 90 days. What does not need to happen is the case does not come off the court's docket.
Mr. Medina?
Our motion, it sounds like, is being stipulated to, and so that's the only thing I'm prepared to address is that the court would...
I haven't looked closely at your, I'm putting it on the record. I want to make sure I understand what your position is.
My position is that it is appropriate to discharge him. The state doesn't object, so I'd ask to discharge him. As to whether he should get a new court date, I object to that. I think that basically the business of the court is terminated for purposes of today. I don't think there's need for an extra court date. If he gets arrested and at some future time based on
That's something different.
So I have two responses to that. Practically, this actually works out in the defendant's favor because right now there's a case pending for which I would assume that he could not be arrested on the warrant. The second response is that there's case law in point, that's Orton v. State, 431, Southern 2nd, 236. This was a case in which similar circumstances had occurred. The 90 days had passed. Defendant had been released from jail. Subsequent to the release from jail, a governor's warrant came down. The defendant was then arrested and transported based on that governor's warrant. When the case went up on appeal, the defendant made the argument that's being made today, that after the 90 days had passed, the case should have been dismissed. This was the first DCA in its 1983 case that disagreed with that position.
So with that, is that not, may I inquire, Your Honor, is that not a situation where there was a second arrest warrant issued versus in this case, he was arrested, he had a Oklahoma warrant, he was arrested in Fort Walton Beach on that initial paperwork versus that case you're referring to, did it not have a second set of paperwork?
No, sir, it did not.
Okay, well then I'm not familiar with the case.
So what are you suggesting the court do as far as keeping it on the dock? I'm not, so should we either put it a few months out as a status?
I would suggest 45 days, Your Honor. I don't know the specific period of time that's going to be necessary for Oklahoma to come back with a governor's warrant or perhaps a response that they don't intend to pursue.
So here's what I'm going to do. Based upon, I haven't had a chance to look at that case law either, but I'm assuming, counsel sounds like he knows what he's talking about. He's citing a direct case. What I'm going to do is, first of all, I'm going to release the defendant. I'm going to keep it on the docket based upon the case law that was cited by the state. Mr. Medina, if you find, and you can write down that case number, if you, after having reviewed it, disagree with it, then bring it back on some type of a rehearing or some type of a review of it.
What is the case citation?
It's 431 Southern 2nd, 236.
And that assumes something that hasn't happened here of a governor's warrant having been issued, which hasn't been issued, but you're presuming hypothetically one is issued. Is that correct?
No, sir. I think that it's clear that we don't have a governor's warrant for today.
And that case did have one.
It did subsequent to the 90 days passing the defendant being released from jail, which of course is why we are asking for a status date so that we can determine if the circumstances match up with the case that I cited.
I don't see why I need to.
So I made my ruling. If you want to contest it,
What is
I'm
this?
offering you that you can file something and put it before me. I'm okay with that.
What is the date, Your Honor? The status date?
Why don't we come back on February 23rd? How about that? Does that work for the state?
Yes,
Is
Your Honor.
that far enough out?
At 9 a.m., Your Honor?
Yes, sir.
I showed the 23rd as at 1:30.
That's just 1:30. February 21st. Thank you.
February 21st at 9 a.m.
And 9 a.m. Correct.
And you want this as a status?
Yes. Thank you.
Thank you, Your Honor.
Thank you very much. And what is that case number? What's that? What's the case number?
431 South Second, 236.
Okay, great.
Thank you, Mr. Rogers. I'll
Thank
check
you.
that out.
Yes. Bruce Applewhite?
Your Honor, I didn't have a chance to get back and talk to Mr. Alton Garth after I drafted the agreement that we worked out. May I have just a moment with him? I'm doing my best to be in multiple places at once. If we want to set it aside, I do need a chance to talk to him.
Well, I understand that. Maybe we can do that with some, while Mr. Gates handles some cases and
That's fine.
trying to,
I'll stretch, Your Honor.
I have Applegarth and Ball that I have sent back agreements to that were reached this afternoon that I do need a moment with.
okay, so why don't you go back and chat with them, Mr. Medina, and I'll do some of Mr. Gates's cases.
Yes,
And
Your
then
Honor.
we'll kind of all be as efficient as possible.
Thank you.
Sure.
We have the inmates lined up in order back there, so what do you want us to do? You want us to
I
send
can-
all of them back to the jail?
I can take one out of custody. TJ can review that real quick.
Okay.
I need to speak with Applegarth and Ball at some point to go over the agreements that I sent back, and I can do that after I see my other people who are in the
Why
line.
don't we do that? Why don't we put Applegarth and Ball back into the cell and make them last, and then we'll bring everybody else there.
Okay, perfect.
For me. Let Mr. Medina get back here.
After you, yeah, we're gonna do all the other inmates before we do Applegarth and Ball. They're gonna be dead last.
I just want to know, when do I go talk to them now or later?
Later. Yeah, when he's doing some of his inmates later. Right this way, sir.
I can recall Michael Crump, Your Honor.
Frank, we're gonna send Applegarth back here and Ball back there.
After speaking with Mr. Crump and the state, I think the state has an announcement of this one.
Second, Your Honor. Mr. Krupp has provided proof that he has a prescription for medical marijuana. Based upon that, the state would move to no process matter.
Very good.
And of course, we'd ask for not to assess the 150, although that was a Mr. Gates. Quick run up and down the stairs, I waive that for Mr. Crump.
You don't think you're worth it?
I would love to, Your Honor, but I'm not going to do that today.
I'm being facetious. We've been at it too long here today. We are not going to apply the attorney's fee, although you probably did earn your keep here today, Mr. Krupp. So the court will accept in all process in this case. Your excuse, sir.
Thank you very much.
Thank you.
Thank you. Thank you.
You're welcome.
Thank you. You're just walking.
Your name? James Banks.
Oh, yeah.
Your Honor, Steve Medina for James Henry Banks Jr. in 22 CF 2960. And we're going to be pleading not guilty in that case. I'm having him evaluated by D. Adams. And I also note for the record, my understanding that he does not have the public defender yet in two other cases. He needs to have the public defender appointed in those two cases, 22 CF.
Are these on the,
I think they're on the afternoon docket today.
today?
Your Honor.
Hold on a second, that's what I wanted to check. All I've got is just the one case for this afternoon.
Okay, well, I may be incorrect that they were on the docket. All I knew is that they weren't the public defender and he needed the public defender in those two.
That's fine, let's go ahead and appoint if we need to.
I've got three cases on here, Your Honor. I've got,
Today?
22, 28, 37, 22, 28, 38.
Yes, those are the two I was referencing.
22, 29, 60.
Right. Right, so he has the PD in 2960, the other two, I respectfully request PD appointment, and that we be able to enter a plea of not guilty today.
Okay. Court will appoint the public defender in those cases. And when do we want to come back just for regular pretrial?
Yes, Your Honor, I would say February 15th, and if we get him on a docket through Judge Schlechter, hopefully we can work something out.
That's fine. You can always move it around. Okay, pretrial 215 for this case, and the other cases that were announced.
Thank you.
Thank you very much.
Yeah, you can take that, yes, sir. Take that. Thank you.
Okay.
Your Honor, this is Damian Rene Beltran. Mr. Beltran is before the court in 22 CF 2552 and 22 CF 3063. I am not sure if a plea of not guilty was entered in the initial case of 22 CF 2552. If not, I would like to have him enter a plea of not guilty today in that case. And he's also going to enter a plea of not guilty in the 3063 case. And then if we can keep him on February 15th.
The court will enter not guilty pleas on both of the cases, 3063 and 22 CF 2552. We'll come back for pretrial on 215 and 9 a.m.
Thank you, Your Honor.
Ricardo Botson.
I don't think he has the public defender at this time, Your Honor.
That's shown as unrepresented.
Okay, how do you pronounce your last name, sir? How do you pronounce your last name?
It's fine.
You can't.
On the same place?
No.
How did we not know this?
Your Honor, could we at least get the public defender appointed? Necesitas un abogado público?
Yes. Court will appoint the public defender.
Okay. Your Honor, I'll go see Mr. Botzak. No, tu nombre es Botzak?
Ricardo.
Okay, Ricardo C. Botzak. If the public defender can be appointed, Your Honor, and
Yes.
he
We'll
can-
enter a not guilty
Not
plea.
guilty.
We'll come back on 215.
That'll be fine, Your Honor, and I'll go talk to him. Thank you.
Thank you very much.
Thank
Mr.
you.
Medina.
Señor, un momento. ¿Sí? Esto es mi nombre. Febrero 15 de febrero. ¿Sí? Voy a visitar a usted. ¿Sí?
I'm impressed, Mr. Medina.
Yes, sir.
Animal?
Yes, sir. Your Honor, Mr.
I would like to plead no contest today, Your
Your
Honor.
Honor, we have an initial point of business.
I don't wish for this case to go any further, Your Honor. I plead no contest, Your Honor.
And I don't mean to, Mr. Campbell and I have been meeting and getting along. If he could pause one moment, let me advise the board of two things. Will you just give me a moment?
I've been getting beat up and persecuted because of being LGBT at the jail by staff and inmates. I can't take it no more of being assaulted and stuff. The laws are caving in on me. I can't take no more. I don't care.
What is the plea agreement?
No contest.
Hold on.
Your Honor, there are two matters. One has to be addressed first, and that he had a court-ordered competency evaluation performed. I've discussed it with him as well as the state. I think the parties are in agreement that he is not incompetent, that we are competent to proceed. There are issues.
Has that determination been made?
The court would need to make that determination.
Let's stop there. Is the state in agreement on that? That he is competent to proceed?
Yes, Your Honor, and I would.
Therefore, based upon the stipulation of the parties and the evaluations, the court will state that the defendant is competent to proceed.
May I just very briefly address the second matter to answer the court? Just let me let the court know when you know, okay? And then the court will tell you what you can do, okay? Your Honor, and I thank Mr. Canmore for his patience. Your Honor, the state has tendered an initial offer to Mr. Canmore as of October 25th, a global offer in 22 CF 2533, 22 CF 2534, and 22 CF, I think it's 2635.
2635.
Right, 50 months DOC. When I met with Mr. Canmore last week, and we discussed the competency issue, then we discussed the assumption that if he did get a finding of competence, that we could proceed with a resolution. It was with the understanding that he did want to take the best deal possible for a deal today. However, he did, through me, I did tender a 36-month deal offer from him. The state needs some time to talk to a victim. There's basically over a year of his life in play here. I think it's in his best interest that he give the state a few more days. He can come back in a week, and the state can have a chance to talk to this one victim about his 36 months offer instead of a 50-month offer. So the state may want to address whether it even wishes to do a plea today, but...
Mr. Zion, I don't really understand what happened. He had paperwork that he was supposed to give to the judge. I've been getting beat up by staff and inmates because of being female and trapped in a male's body. And I'm asking the court for, I'm here to get out of the state of Florida, banishment from the state of Florida. I've been going through a lot of persecution in that jail because of being female trapped in a male's body. They don't like females, and they've been beating me up, staff and inmates. And I can't take it no more.
Listen to me, listen.
I want banishment from the state.
Listen to me.
I want banishment.
You're saying you want to accept the 50-month DOC?
I want banishment from the state of Florida. I really don't care. I want to be banished from this state.
That's not one of the options.
Well, the thing, I really don't care because all I'm doing is I'm getting beat up. I'm being persecuted. Nobody's listening to me. Mr. Zion had paperwork he was supposed to give to the judge for me after he talked to me. It's like I'm being pressured and I'm being tortured and nobody's caring about my life or anything. And I have family that works in the prison system everywhere that I don't care. I plead no contest. I don't care if you give me prison or whatever, but I can't take no more of the abuse and being ignored and they're steady getting ready for me being in that jail, but yet all I'm getting is beat up and persecuted part of my life. I had a mental health counselor. I got mental health records that could have been faxed. The subpoena this is taken, and then nobody's got my mental health records so I could get my medications that were took from me and never came back to me, my staff and stuff. And this is all that's been going on. I'm just being getting persecuted, dragged, tortured, psychologically, emotionally, and physically at that jail. And they refused to get my records that they could have done 100 years ago from the state of Florida or the state of Georgia.
When we pass over this case, we'll come back a little bit later today. Let's just pass over this case for just a few minutes.
Thank you, Your Honor.
Okay. We'll address this a little bit later today.
Yes, sir.
Frank David Canterbury's going to need to see last of the other people.
No. Keep him out.
Colleague.
Counsel.
Maybe we
I want that previous case.
Just a moment, Your Honor.
You may.
Thank you.
Edward Colley.
Okay, very good.
Your Honor, may I proceed? I'm sorry. Thank you for your indulgence, Your Honor. Steve Medina with Edward Dillon. Colley, C-A-W-L-E-Y, and 22 CF 3029. Your Honor, we have evaluations pending at Keaton and Phoenix House. At this point in time, we need to enter a plea of not guilty, and he could remain on February 15th, and we can hopefully get a resolution by or before then, Your Honor.
Very good. Court will enter a not guilty plea and will come back for pretrial on 2/15.
Thank you, Your Honor.
Chartran.
Did the state announce on this?
Yes, Your Honor. This is 22 CF 3012 and 22 CF 2721.
All I've got is the first one on here. I don't have the second one. 22 CF 2721 is.
Oh, I apologize, Judge. I think that he has Mr. Medina on the 2721 case.
I did not have any files showing him as having court today. What does he have court today in that has the public defender?
2721.
Yes, sir. He is set for your February 13th docket, which would be February 15th. He pled not guilty back in November of last year.
Okay, so what we'll do, Mr. Charlton, this case that's before us today, the 3012, I'm going to go ahead and enter a not guilty plea, so we can track these cases together. And you do have a right to an attorney. The other case is a public defender.
Yes, sir.
So I assume you want to have a public defender on this case too, right? Yes, of course. So the court will appoint the public defender, so both of your cases will come back on 2/15 at 9 a.m. for pretrial.
Excuse
Okay.
me, Your Honor. I'm having trouble at the county jail. I was on medicines, and when I entered the county jail, they've withheld my medicines, and it's important. I'm on them. I just wanted to bring it to your attention because I've tried everything in the world to get it at the county jail, and I'm not getting no help out of it.
I'm not saying that I don't, that's Mr. Medina. Anything that can be done?
Your Honor, I have no,
I just don't know.
Nor does I don't know if the court, sometimes we inquire, but basically it's up to the jail to administer such medications as their medical staff deem appropriate.
Here's the problem, Mr. Charlton, and I'll just tell you straight up that, sometimes everyone thinks that judges are all powerful, but, we actually have different arenas of responsibility. And that's not one of mine. I don't have any authority over it.
And I was
So
on them
even
that
though,
presumed that.
even if I were something, and I'm not, if you have medications and you're not getting them,
Yes, sir.
I know it can be a very severe problem, but
Yes,
I don't
sir.
have any,
Yes, sir.
I'm not aware of any authority I have to do anything about it.
Thank you, sir.
Okay. Thank you.
Your Honor, he is in my jail bucket, and I will go see him as soon as I can. I just did not realize he had court today.
That's all right.
Thank you.
Well, he came in, he didn't have any attorney on this case.
Yes, Your Honor.
So you're appointed this one to now, both the cases.
Thank you, Your Honor.
Okay.
He wasn't in jail in November.
Yeah, that's right. And you can move that other one to 15 too.
Yes, I moved both.
Thank you very much.
Collis.
Christopher Collins.
Your Honor, this is Christopher, how do you pronounce your middle name, sir?
Dushar.
And last name Collis. And Mr. Collis is before the court in 22 CF 1271, 22 CF 1273. Those are BOP cases, and he would deny the BOP in those two cases. And then he is also before the court in a new law case, 22 CF 3027. And he would plead not guilty in that case. He and I have met. He would like to review video, and we will be, if we can, leaving him on the February 15th docket.
So we'll enter a not guilty plea today, and we'll come back on a pretrial February 15th at 9 a.m.
Thank you, Your Honor.
Your Honor, before you leave the podium, I did file a notice of intent to seek habitual felony offender sentencing. Can the record reflect that I have handed that to Mr. Medina in the courtroom, and Mr. Medina has handed that to his client?
Very good. The court will so note, and the defendant can go over that with his attorney. Madam Clerk, please fill in the offender.
Thank you, Your Honor.
And Madam Clerk, did you get, I only have one case here today. I just want to make sure all the cases that Mr. Medina have are all traveling together on 215.
22-1271 and 22-1273 of the DOPs.
Yes, were they not on the docket today? My list said that they were.
Yes, sir, they're on the docket.
So he would enter denial in those two cases.
They're not on my list. That's it.
Thank
We
you.
just want to make sure we get them on.
Daniels.
Yes, sir.
Daniels.
This is Christopher Lee.
Christopher Lee Daniels.
Your Honor, Steve Medina with Christopher Lee Daniels. There's been a lot happening in communication between the alleged victim and the state, and the state and I have been trying to discuss things. Do we have an ability to resolve his case today for Christopher Lee Daniels? I had sent the state a proposal for a misdemeanor resolution. Okay. Your Honor, this is one where the court, or at least the clerk, forwarded to us a to whom it may concern letter from the alleged victim, Kristen Gross. Assistant State Attorney Sharpless is indicating that additional time is needed to evaluate it. I have provided the state an offer for a resolution on a lesser included offense misdemeanor simple battery with anger management course, 11 months, 29 days probation. He does have with the alleged victim, there's a newborn baby that my understanding is in foster care, and he's desperate to keep that child. I guess the state is saying it's not prepared to do a deal today, but we can bring him back in a week. I guess that's the state's position. So he would certainly like to come back sooner rather than later, rather than February 15th.
Is the state, would it be helpful to come back next week?
It would, Your Honor.
Okay.
I need to speak some more with the victim.
We'll continue until 1:17 at, why don't we do it in the morning?
Yes.
So we'll enter
Is the alleged victim here?
We'll enter a not a guilty, but, is this a new law charge here?
Yes, Judge. Now,
So we'll enter a not guilty plea, and we'll come back for a status on 1:17 in the morning.
Your Honor, Ms. Gross, the alleged victim, is present. Would the court indulge to allow the state to talk? No, not today.
We'll talk at night.
Okay. It's not going to get resolved today, so status in a week, Your Honor. Thank you.
Okay, thank you very much.
Lewis Dawson.
Your Honor, this seems like this is a day where some things are easy and some things are complicated, but Mr. Dawson, Lewis D. Dawson, is before the court in 22 CF 2962. The state indicated to me late yesterday that it had communication with the alleged victim in this case, that she was okay with mental health court. However, he was wanting to do an option that the state had extended to him of doing 6 months community control followed by 3 years probation. He was requesting, and I drafted and provided to the state, a lesser included offense aggravated assault plea and sentence agreement. Does the state have the capability or desire to enter that agreement today? Because we can take care of it. Would it be as charged? So we can plea as charged on that?
Well, he needs to be, has he been evaluated by?
It would not be mental health court. Remember you said it would be, with mental health court, it would be on like 18 months, so this would be.
When we take a break, you all are welcome
Yes,
to
thank you,
chat
Judge,
about
sorry.
it. We'll pass over this. We'll chat about it later.
All right, can we recall him, Your Honor?
Yes.
Thank you.
All right, Mr. Dawson's going to have to be seen with the last three. Yeah. Just to the left.
Elliot?
Yes, Your Honor, Matthew Lee Elliott is before the court in 22 CF 3052. Mr. Elliott is being evaluated for Phoenix House in Keaton, and he would like to plead not guilty today, Your Honor, and we could leave him on February 15th.
Very good. The court will enter a not guilty plea and will come back on February 15th at 9 a.m. for a pre-trial.
That's right.
Thank you. Thank you.
Thank you. Forrester? What letter is he serving?
He's not doing it, but you're. Hey, Mr. Medina, it's all his after that. You want to go talk to the boys?
Yeah.
Mr. Medina's headed to the attorney fire. He needs to talk to all one.
Mr. Forster, this is case number 2022 CF 3018. You do have a right, we're here on a plea today, plea docket. You do have a right to have an attorney appointed. Are you planning on hiring a private attorney, or do you want me to appoint a public defender?
Appoint a public defender.
Okay, so I'm going to appoint the public defender. You still have to fill out the form, make sure you qualify. We'll give you that form, you can fill it out. So I'm going to go ahead and enter a not guilty plea on your behalf, just to protect your rights. You don't give up any rights. So you have a chance to meet with your attorney and talk about what are the different options, okay?
Senor, can the state put the offer on the record for Mr. Forrester?
Current offer, there are, Mr. Forster has two pending cases. One is down in county court, that's 22 NN 4378, which is the same victim. In this case, 22 CF 3018. State's current offer is a plea as charged, in this case, with a dismissal of the case in county court, that's 22 NN 4378. That would be a withhold of adjudication, 2 years of probation, court costs, PD fee if applicable, no contact with the victim. Joanne Forster, Batterers Intervention Program, no objection to a modification to no violent contact if that contact is requested by the victim.
I don't know if Mr. Forrester wants to consider that, but if we can bring him back next week for a status, I'd like to at least have a conversation with him, because it is a plea that would result in his release.
I would like to be released as soon as possible.
That was my anticipation, and I don't want to do it today because I want to make sure he understands all the rights. But if we could do it Tuesday, that'll give me time to go out and see him and make sure he understands everything.
Okay, let's come back on the 17th at, in the morning, 9 a.m. for status. Who's the alleged victim in this case?
Your Honor, one looking it up, it's Mr. Forster's mother, who's my understanding based upon the allegations.
You need to look at whether BIP is appropriate when you're dealing with that. I'm not sure it is.
Your Honor, my concern is that it's required for specific domestic violence pleas by statute. But I will certainly be ready to address that on the 17th, Your Honor.
That's fine.
Do you want me to go ahead and do it on guilty plea today, Your Honor?
Yes, ma'am. I'm sorry, I thought that was my bad.
Your Honor, this is Mr. Hartzog before the court. We have a plea agreement to be filed in this case. It'll be covering both cases before the court. Mr. Hartzog is pleading to probation. Just so probation is aware, he does have a warrant or hold from Jackson County. He and I talked about it. He's not sure what it's for, but I'm not sure if he's going to be released prior to being picked up in Jackson. Your Honor, Mr. Hartzog will be pleading no contest as charged, and the case is before the court. He's going to be adjudicated guilty on all counts and cases. In 22 CF 2492, he's sentenced to 36 months of probation concurrent, waived the cost of supervision, 615 court costs, $150 defender fee, a substance abuse evaluation within 30 days, and I'm going to write on here from release, Your Honor, just to be safe, because I don't know when he's going to be released from Jackson County. And then the same with the recommended treatment as well, to be safe. For anyone else in the 24 hours of community service work. And then 22 CF 3036, counts 1 and 2, 3 years of probation concurrent, waive cost of supervision, 615 court costs, and $100 public defender fee. I may approach that.
Stated agreements.
Yes.
You're okay with the score sheet?
I don't think it's maybe a downward departure for the plea bargain.
And, Your Honor, I believe it is. I believe Mr. Hartzog scores 13 months. This plea is based on a legitimate uncoerced bargain.
Very good. And he and I discussed that, and I explained to him that what that means for him is that any violation is a DOC start point.
Okay, very good. Mr. Hartzog, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
So you heard your attorney state the terms of the plea agreement. Put your hand up. Your attorney stated the terms of your plea agreement, and I see it's written in this written plea and sentencing agreement. Have you gone over it in detail? I see there's a lot of check marks in here. Looks like you've gone over it in detail to make sure you had all your legal questions answered about this plea agreement. Have you done so?
Yes, Your Honor.
And you feel like you've gotten all your questions answered by your attorney?
Yes, Your Honor.
I understand that by entering this plea agreement, accordingly, this will be a final adjudication of this case, waiving all rights to go to a trial and to contest, etc.
Yes, Your Honor.
Believe this in your best interest to do this?
Yes, Your Honor.
Nobody threatened or coerced you?
Yes, Your Honor.
Okay, very good. Based upon that, the court will accept your plea. The court will sentence you to 36 months of probation on all 3 counts. They will all be served concurrently. There are a number of fees and costs that are contained in here. In addition, as a condition of the probation, you must have a substance abuse evaluation within 30 days from release and start any recommended treatment within 60 days from the release. And we also have 24 hours of community service hours. Any questions?
No, thank you, Your Honor.
Thank you.
Right this way, sir. You're on the hat.
Your Honor, this is Jermaine Hatton. We have one case on the docket today for Mr. Hatton, that's 22 CF 3061. Information was filed alleging fleeing or attempting to elude.
Mr. Hatton, you do have a right to an attorney with this new charge. You wish to have an attorney appointed.
Yes, I'm going to hire John Reed.
Okay, so I'm not going to appoint you a public defender. The court's going to go ahead and enter a not guilty plea on your behalf here today, so you have a chance to meet with your attorney. Assume you're going to get up with your attorney quickly.
Yeah, I have a question.
Sure.
Is there any way I can have my bond reinstated?
And it's not before the court today. So, of course, enter a not guilty plea. We'll come back on 2/15 for pre-trial. So I'm sure you'll meet up with your attorney before then. Thank you. Charles Johnson.
Your Travis Gates on behalf of Mr. Johnson. At this time, we're going to be entering a not guilty plea to Mr. Johnson's 2 cases before the court. Actually, we may just have one case for the court.
I've only got one.
It looks like his other case, 22 CF 1176, has already been set for February the 15th.
Okay.
So if we can have this one set for February 15th as well.
So I assume you're entering a not guilty plea?
Yes, Your Honor.
Court will enter not guilty plea, set the pre-trial on February 15th at 9 a.m. Now, Madam Clerk, I have two cases that have private attorneys that not been around. One is Michaela Crandall and Mr. Arrowwood. Is that who's your name? There is not.
Mr. Wayne and Shelton.
Okay.
The only filed a notice of appearance. There was an order granting substitution of counsel.
Who's substituting?
Substituting,
Mr. Medina and Mr.
counsel was granted, also the defendant is hereby released, and Arrowwood Law Firm is appointed, but Mr. Arrowwood did not file a not guilty plea.
Okay, well, we'll do it in a second. This is Mr. Shelton. Mr. Shelton, have you been in contact with Marty Notes?
No, sir. There hasn't been a meeting.
Do we have verification that Mr. Notes is appointed and that he's received notice of it? He's very good about it.
In a couple of months.
On this case?
Yes, sir.
There was an order granting a motion to withdraw on January 9th for the ORCC with Mr. Notes being appointed.
Okay, here's what I'm going to do. I am, on both of those cases, Mr. Michaela Crandall and Mr. Shelton cases, I'm continuing this until next week, on the 17th, and I will make sure to find out what's going on. So we'll come back on the 17th at 1:30, continue to 1:17 at 1:30. I don't know what the miscommunication is, but we'll try and get to It'll be, your attorney is Marty Notes. He's very experienced criminal attorney.
Yes, he said she does not.
Okay. So what do we have left?
He's saying Marty knows pulled off his case.
Well,
Your Honor,
okay, we'll follow up with this.
my three that we deferred, I talked to them, we're ready to go on all three.
Okay?
And then he ordered Applegard, Ball, and Dawson.
Mr. Applegard?
Thank you for your indulgence, Judge. Your Honor, Steve Medina with Bruce R. Applegarth in 22 CF 3037. You have the piece, or I have the agreement, Your Honor. He's signing the agreement that we've previously been over. Sorry, it's hard for you to open it. Thanks, sir. I got it. Your Honor, it's my only copy, if I may allow Ms. Sharpless to review and sign. We need to discourse. Your Honor, under this agreement, Mr. Applegard will be changing his plea of not guilty to no contest. There will be an adjudication of guilt. And it is as charged to count 1, possession of controlled substance, and count 2 of possession of paraphernalia. He'll be doing 90 days concurrent Okaloosa County Jail with credit for all time served. There will be $615 court costs, 150 PD fees, and I'm writing in here 12 months to pay upon release prior to monetary obligations going to collections.
But the agreement of the state.
Yes, that is the agreement of the state.
Mr. Applegarth, would you raise your right hand, sir? Yes. Swear or affirm that the information you're about to provide the court is the truth, nothing but the truth, so help you God?
Yes, sir.
Just need to ask you a couple questions after Mr. Medina.
Yes, can I just have an initial on the 12 months to pay
Sure.
upon release prior to monetary obligations going to collections? That's fine. Thank you. Thank you, Your Honor. Mayor,
Hey, Mr. Applegarth, you heard your attorney state the terms of your plea agreement. The core of it, an adjudication of guilt, and on both counts you get 90 days in the county jail, credit for time served, concurrent, so they're not stacked on top of one another, running together. Okay? Plus you got a bunch of fees and costs, of course. You'll have 12 months to pay those upon your release.
Okay.
If not, they go to collection.
Okay.
Okay? Is that your understanding of the agreement?
Yes, it is.
Okay, and you see you signed the plea and sentencing agreement. Have you gone over with your attorney, got all your legal questions answered?
Yes, sir, we just did that.
You do understand that you're waiving the right to go to a trial, and this will be a final adjudication of this case?
Yes, sir, I do.
And you understand that by entering into this, this case will be finally resolved?
I do, yes, sir.
Okay. Nobody threatened or forced you to get you in or anything?
No, sir.
Okay. Very good. Based upon that, the court will accept your plea, sentence you to the 90 days, county jail for each of the counts concurrent, the fees and costs.
Okay. Yes, sir.
Good luck, sir.
Thank you.
State, you're in agreement on the score sheet?
Yes, Your Honor. I do agree.
Thank you, Your Honor.
Thank you.
Thanks, Bob. Your Honor, Mr. Brandon M. Ball is before the court at 22 CF 3044. The state has given him a probation deal. However, he's homeless and wishes me to try to negotiate a straight jail deal. He thinks that's in his best interest. I think he's being wise in his assessment of his limitations of transportation and residence and so forth. So I'm asking to do a brief continuance for a straight jail negotiation. I would think that we could have a conversation to that effect with the state and get it resolved by a week from today if the court would permit a status on January 17th.
So the court will go ahead and enter a not guilty plea today, and the court will come back for status on 1/17 in the morning.
Yes, sir.
In the AM. Okay?
Thank you, Your Honor.
Hopefully
You can go on to that in the meantime, okay? Thank you. I'll see you when we get it worked out. Assuming that happens.
Okay.
Dawson? Your Honor, Mr. Lewis D. Dawson is before the court in 22 CF 2962. I have met with him yesterday and gave him a draft plea and sentence agreement that we went over. There has been one significant change, and he is going to initial that change, which I discussed with him, and then I'll make sure it's clear on the record. Go ahead and initial the as charged. Your adjudication of guilt is as charged. Yes. Okay. You got it? You read. You can read that as charged. It's 3 years. Yeah. 3 years, same as 36 months. Your Honor, the agreement that has been reached with the state is that he does need to sign. I'm sorry, Judge. Thank you. Your Honor, under the agreement that has been reached and now signed by all parties, Mr. Lewis Dawson will be adjudicated guilty as charged, and he's initialed that with LDD next to as charged. 6 months community control, followed by 3 years standard probation, $967 in court costs, $150 in public defender fees, 24 hours community service, no contact with Bethany Ann Vangezen, it's Vangzyzen, Van Geisen, anger management course, mental health evaluation within 30 days with any recommended treatment commenced within 60 days, monthly urinalysis, remain gainfully employed or complete 2 job applications per week, no weapons or firearms, no drugs except as prescribed, and no alcohol. And I do need to put a couple things on the record regarding things I've informed Mr. Dawson about. One is that I was trying to get him a lesser included offense, possibly would have been a third-degree felony aggravated assault. He may also have defenses in the case, but he believes it's in his best interest to enter this plea as charged, and that will allow him to get out of jail today. He doesn't believe anything else is holding him, so he thinks it's in his best interest. The second thing is that he has declined an option to be evaluated for mental health court, which might have resulted in him having Judge Schlechter for mental health court with a possibly an 18-month probation term versus 6-month community control followed by 3 years. I've explained to him he would need to get evaluated and approved by Judge Schlechter, but he wants to do this deal today. It's a best interest decision on his part. I'm not recommending it, but he thinks it's what he wants to do. Does the state have a score sheet?
Yes.
May I approach, Judge?
You may.
Thank you.
Thank you.
Thank you.
Mr. Dawson, would you raise your right hand? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God.
Yes, Your Honor.
So you heard your attorney state the terms of the plea agreement.
Yes, Your Honor.
And I see that those same terms are contained in the plea and sentencing written agreement that you signed.
Yes, Your Honor.
Let me see, make sure you signed. So have you read through this and have you gone over it in detail with your attorney?
Yes, Your Honor.
And you heard some of the other options that were out there. Your attorney stated, honestly, he stated even that he wasn't really recommending that you take this deal here today. But here you are. Are you wanting to take this deal without the other things that are on the line? Possible mental health court, which would be shorter and would have some other services that might be involved. You're clear that this plea agreement is more to your liking or in your best interest?
I am, Your Honor, but my current situation, I take care of a 100% disabled person at home, and he has nobody to take care of him right now.
Who is that?
My roommate, Jason Register. So if he falls, he doesn't have a life alert, and usually when he falls, he's not near his phone, so he lays there until somebody comes and either finds him or comes and checks on him.
And you also have 13 pets or something?
Yes, sir, 13 pets.
Okay, well, this is your call. I mean, it's you have the right to make these decisions. I just want to make sure you're doing it with your eyes wide open.
Yes, sir.
Okay, at least I understand why you're doing it. You understand this is the final resolution of your case?
I do, sir.
I mean, obviously, you're going to be on the probation, so but as far as resolving this case to this point, do you understand that?
Yes, sir.
You're not going to go to trial, no further court hearings on this as it relates to this, assuming you don't violate. Importantly, there is a no contact with this Ben Geisen. You understand that?
Yes, sir.
That's one-sided no contact. I don't know any of the circumstances, don't know what it is. All I know is it's one-sided no contact. So if she contacts you, guess who's in violation?
Me.
No, not her, you.
So she can come to my residence?
That's exactly right. She could come to your residence. Now, if she comes to your residence, I'd be calling 911. But, because she's not supposed to be at your residence, right? It's your residence.
Yes, sir.
Does she have some reason to be at your residence? Okay. So like if you were at a restaurant, she walked in on the restaurant, you'd have to leave.
I have to leave the restaurant.
Yeah, so I mean, you have to receive, look,
Say one.
I've never had any problem with it. I just want you to be clear with the parameters.
Yes, sir.
You're not gonna get, nobody's gonna trick you and get you to violate because you bumped into her in Walmart. But you need to understand that it's your obligation, and there's no contact, particularly when it's the basis of a plea agreement, and you'll get violated and they'll pull you right back in.
Okay.
Okay, so you need to stay away. If she tries to reach out to you, she calls you, don't pick up the phone, she texts you, don't do it, okay?
I'm going to delete her numbers and Facebook and Instagram and
Absolutely.
everything.
You don't need to have any contact whatsoever.
Yes, sir.
That's a condition of this thing. So you got 6 months of community control, that's house arrest.
Yes, sir.
A lot of conditions on this, you're gonna have to pay close attention to this.
Like
You
I
willing
said,
to do that?
I stay at home 24/7 and take care of my roommate.
Okay, very good. Based upon that, court will accept your plea, and you'll be adjudicated guilty and as charged, and you'll receive 6 months community control, followed by 3 years of standard probation and fees and costs. And you also have an anger management course and mental health evaluation that you have to submit. Normally, probation from Crestview, which should they do first? Generally, the mental health first? Mental health evaluation?
Yes, sir.
Okay. Because we've got both of these down here, but we want to do what's most efficient. It seems. I think generally that's the way they do it, right?
Yes, sir.
Okay.
You need to report first thing.
To probation.
8 a.m. tomorrow morning, 13 Kelly Avenue.
If it's possible to get an address from Mr. Dawson.
Sure.
Give me your address.
What's your address, sir?
You can just say it out loud here at the podium.
342.
Cop showed up late. I think he issued a warrant for him, but he's in the yard.
Okay. Very good. And you're okay with the score sheet? On that?
Yes, Your Honor.
So, Cox.
Mr. Cox, come on, Brooks. Not you, sir. 1 second. He's Cox.
What is your name, sir?
Jeremy.
What's your name?
Ryan, R-Y-N.
Jeremy Ryan.
No, I've got it on mine, but I have it that he was,
Nina Cox.
yeah, there's, I got that one too, Nina Cox. So did we issue a capias on this one?
No, so I did this the last minute she's done that. So this is being addressed.
Okay. And there's no attorney, it's been. So this is case number 22 CF 3028. You do have a right to an attorney. With this matter, you wish to have an attorney appointed?
I'd like to hire one.
Okay. So the court's going to enter a not guilty plea on your behalf, and we'll come back on pretrial on February 13th at 9 a.m.
Yes, sir.
Okay? Try and get your attorney lined up before then, okay?
Yes, sir.
And meet with you.
I apologize for being late.
Okay, thank you.
Roderick Bryant?
I have nothing further, may I be excused?
You may.
Governor Steve Medina for Roderick E. Bryant in 22 CF 2925. We're here on a motion for bond reduction, Your Honor. There also is a separate motion to dismiss.
Hold on a second. So are we done with the rest of our pretrial?
Oh, I apologize, Your Honor. He was next on the 2:30 docket, and I saw this.
Yes,
He's on the 2:30, so.
I don't think this is gonna be an hour-long hearing, but it may be about 20 minutes, so yeah.
Yeah, I think we need to at least take a break. This is a break. So we finished with I just wanted to make sure we're good on.
I don't know if there were any housekeeping issues that Madam Clerk wanted to address, Your Honor.
I had a housekeeping issue.
Yeah, I think we've got,
Yeah, come on back.
The
we're all
fugitive
good.
from justice case.
Do you have any other one? Which one?
The fugitive from justice case.
Alvarez Rodriguez.
Which one is that?
I have Joshua Cornelius.
Oh, we're looking at number 1 on our docket, Judge.
I'm sorry.
Number 1?
Yes.
Yes, ma'am.
Alvarez Rodriguez. Kenneth Alvarez Rodriguez.
So, Your Honor, you issued a capias. The state is going to request that you withdraw that. Mr. Alvarez Rodriguez, I'm not completely certain of why this occurred. He was picked up for a second time on an FFJ after he had already waived extradition. Looks like he was out of custody pending pickup from Puerto Rico. He's got a court date set on 2/13. It just seems inappropriate that the court would issue a capias when he was picked up 2 days ago. He's already waived extradition. It'll be a different situation if he doesn't show up.
So what do we have to do today?
Just withdraw the capias and we'll leave it set for February 13th.
Okay, so we'll withdraw the capias and we'll set it for 2/13. Okay, thank you for clarifying that.
Yes, sir.
Okay, anything else we need to do on the arraignment document?
I don't think so, Judge, except there may be some that didn't show up or can go back to address Ms. Crane, but if we want to do that after Mr. Bryant's.
Well, we've got 2 that aren't here. And one of them was represented by Mr. Arrowwood.
That's Mr.
And one of them was represented by Mr. Noakes. And I continued both of those for 1 week. And I'm going to call their office, not me personally, but our office will be in contact with their office, asking them where they're at. Hopefully they'll be here next week to represent their client. Anyway, we'll take a short break in the afternoon. So we've got, what do we anticipate? I know we talked about it. We got the bond hearing from Mr. Bryant.
And then for Mr. Lucas, Your Honor, I'm very quickly drafting a very brief resolution agreement for DOP, sending it back to him. I need a minute with him to discuss it, so we'll be hopefully ready to go here.
Okay, so we'll be back in 10 or 15 minutes, so we're not going to be long.
Judge, that's all for me today.
Have a great day.
Thank you.
Same as me, Your Honor. I'll be, if the court will allow, I'd like to be excused as well.
Take care. You have to say.
Thanks, Travis.
You're welcome, Steve.
I'm going to run hit the restroom.
William F. Lucas is approaching 20 CF 1694. He's signing his plea and sentence agreement that we've previously been over. Whoops, sorry. And the state will be submitting a score sheet, but my understanding is he would not score DOC. It's a BOP without a new law felony anyway, but just for the record. Your Honor, under the terms of Mr. Lucas's violation of probation plea agreement, he was previously adjudicated guilty to a felony battery. He would be revoked and terminated in terms of his supervision. He will be doing 10 months Okaloosa County Jail with credit for all time served. He represents to me, I don't have independent knowledge, but he thinks he has 9 months or thereabouts. But of course, that's up to the jail to calculate specifically. 10 months Okaloosa County Jail with credit for all time served, as I stated. $100 VOP fee, $150 public defender fees, 12 months after release prior to the unpaid monetary obligations going to collections. May I approach, Your Honor?
Thank you. Okay.
And Your Honor, I may need that back because this is not the form I usually use. I need to write the word admit on there for him to initial. I went over that with him. I apologize. I usually use it off the computer, but I'm just writing admit VOP, and he sees that right there, admit VOP, and he's going to initial right by those words. Yeah, it's right there. That's fine. Thank you.
Mr. Lucas, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the plea agreement.
Yes, sir.
Revoke and terminate supervision so your probation will be finished. You get 10 months in the county jail, credit for all time served, plus the fees and costs. And you have to pay the fees and costs within 12 months after release.
Yes, sir.
Or it'll go to collection. Is that your understanding of the plea agreement?
Yes, sir.
You understand that by entering this plea agreement, you're waiving the right to go to a trial, giving up some valuable rights. You believe this is in your best interest?
Yes, sir.
And you understand that this will be a final resolution of this violation. You'll be completely finished with it. You don't have to come back to court or anything on this. Do you understand that?
Yes, sir.
We'll actually sentence today and you'll be done with it. Do you have any other, have you had all your legal questions answered by your attorney regarding the plea agreement and any matters related to the plea?
Yes, sir.
Okay. Do you have any further questions?
Just one.
Okay. Ask him first. I don't mind listening to you, but I want to make sure that you don't.
Oh, yes, Your Honor, he's just wondering to whom he inquires as to the total amount he owes, and I believe that state probation would say he would talk to the clerk of the court in Okaloosa County would advise you as to how much the total amount is on your fees and costs.
Yeah, I mean, for this one, it's an extra $250. It's
Right.
$150 PD and $100 VOP. I don't know what else is outstanding.
And whatever would be the VOP.
1,367. Does that include the 250 or?
No, sir, it's just what's on the case, I don't know.
There would probably be some outstanding arrearages on
His probation fees
probation fees.
usually kind of go away when we revoke them.
Okay.
So the one thing I would suggest to you, you've got to pay these things. When you get out, set up a payment plan. You know, if you've got 12 months, divide it by 10, pay $150 a month. You know, get that done, because if not, you're right up against it at the end, and you know, you need to put this behind you. And I know it's a pain in the rear to pay all these fees, I get it. But if you break it up into all of it, then, you know, it'll work.
It'll be done.
You need an elephant in one bite at a time.
I'll make sure.
Okay?
Yes, sir.
Okay, any other questions regarding this?
No, sir.
Okay, the court will accept your plea agreement and sentence you to the 10 months in the county jail, credit for all time served, as well as the fees and costs contained in the agreement. And we have a score sheet?
Your Honor, I'll have to submit that later. I did have it done, and then the printer.
Is this a downward departure or not?
No, Your Honor, it'll be a guideline sentence.
Okay.
And, you know, for the record, it's technically not a guidelines because it's a BOP without new law, just respectfully, I wanted to nuance that.
Keep her straight.
Yeah, well,
That's all right.
thank you.
Right this way,
Right,
sir.
thank you.
Thank you, Your Honor. Thank
But
you.
he does not have more than 44 points.
Correct.
Right.
Got it.
Do that. Good about that.
Oh,
Your Honor, next is, if I may proceed on the motion for bond and Roderick E. Bryant, 22 CF 2925.
Your Honor, may probation be excused?
You may.
Thank you, sir.
Thank you for your assistance today. Can you get me a copy of the motion for bond? Because the motion for bond is contained in the court file. Is actually the motion to dismiss.
Just,
It's not your fault.
the only motion for bond that I have, the only copy is, I've got all my notes on it. I don't think I could appropriately provide that to the court.
Well, if you don't have a clean copy, just make sure you walk it through real slow.
Yes,
for me,
Judge.
and I understand.
I'm surprised that it's
You
not.
see that?
If it works,
That's weird, isn't it?
is it possible to print that out for the court?
Your Honor, I have a copy, and it's a clean.
Sorry.
Oh, you have a copy?
She's printing
I
out.
have it on the case on 22 CF 2925, docket entry number 32.
See mine, see it bond? I have the same, that's. I got it. You're right, it's right where you said.
You okay with giving another copy?
Yeah. Yeah, I can print another copy.
It's
and
clean.
have it.
Okay, go ahead.
Thank you, Your Honor. Just a logistical question, because I anticipate that Mr. Bryant's significant other, the mother of his children, would testify briefly, then he will testify, then I believe the state intends to put on a family witness of the victim, the alleged victim in the situation. Would it be better if Mr. Bryant sat down for this?
Sure, absolutely.
Thank you. And then if I could, if that's okay with the court, I'll call my first witness is Amber Agrit.
Very good.
Thank you.
And you may stand at the podium if you wish, or you may stand at the desk, or even sit at the desk. It's okay.
Thank you.
I'm pretty flexible.
I'll stand at the podium if you don't mind, Your Honor.
Ma'am, would you please raise your hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Please be seated. You may inquire.
Thank you, Your Honor. Ms. Agrit, would you please state your full name and spell your last name?
Amber Lynn Agret, A-I-G-R-E-T.
And are you in a long-term relationship with the defendant, Roderick E. Bryant?
Yes, 9 years.
Okay, and do you have children with Mr. Bryant?
Yes, a 2 and a 4-year-old.
Okay, and do they live in the home with you and you normally with him?
Yes.
Okay, and for the record, where do you live normally with Mr. Bryant?
Fort Walton, 110 David Street, 11F, Fort Long Beach, Florida.
And are there some issues of a financial relation to his being incarcerated with respect to eviction?
Yes,
possibly?
we are getting evicted.
Okay. Could you explain to the court your understanding about his employment, his 2 jobs, and how important that is to keeping a roof over your head and other obligations of the family finances.
Yeah, he works 2 jobs, typically overnight, so our kids, we swap kids, you know, like I take him while I'm at work, he takes them while he's at work, but he's the main provider in the home.
And you work as well, where do you work?
Taco Town.
And what, is that full-time, part-time?
Part-time, because I have 2 small children, I can only work when they're in school.
Okay.
And they're only open from like lunch to dinner, so.
Okay. And does he have 4 other children besides the 2 that he has with you?
Yes, and he has child support with those that he pays.
Okay. And in terms of your family finances, if the court were willing to enter a signature bond, then this wouldn't be involved. But if the court were to order a cash or professional bond, is there a combined amount to a bondsman that you would be able to pay within the next week or 2?
Probably no more than $1,000, and that is a stretch. That's like all my paycheck.
Okay, and that would be basically to a bondsman of a $10,000
Yes.
bond,
Yeah.
total cash or professional
Yes.
between combined bonds. Okay, is there anything more that you would like to tell the court about your family, especially your 2 minor small children living at home, and how how you need him?
Well, he just was the main provider, so I haven't been able to pay anything. Everything's in his name. I can't even get help paying anything because his name is all the bills, all that, like there's no anything without him there. Like we're losing everything.
Okay. All right. I don't have any further questions, Your Honor.
Do you have any questions?
No, I don't have any questions for this witness.
Thank you, ma'am. You step in. Who else do you wish to call next?
I just wish to call the defendant, Mr. Bryant, sitting where he is, if I may, Your Honor. Or if we're going
to put him up.
Okay. Thank you, Your Honor.
Sir, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Yes, sir. Please be seated.
Mr. Bryant, would you please state your full name?
Project Eugene Bryant.
And you are the defendant in 22 CF 2925, for which you are presently incarcerated in Okaloosa County Jail. Is that correct?
Yes, sir.
You've heard your significant other, Ms. Akrit, testify, so I'm not going to go over everything she's testified, but I want you to talk about a couple things. Number one is, what are the 2 jobs that you have, and explain to the court the relationship, contract job, and so forth on those 2 jobs.
Yes, sir. I work for DSI at Walmart in Destin, overnight stocking. I work from 10 to 7, and I get off that job, and I got another job at Northwest Florida Daily News. I deliver papers for the Shalimar area.
So that's basically working full-time, overnight stocking at Walmart, and then you go do the papers for the local newspaper.
Yes, sir. The DSI job in Walmart help me pay half my child support, and my other job I pay rent with.
Okay. How many children, other than the 2 living in the home, is it that you actually pay financial support that's court mandated?
2.
Okay. What are the amounts that you pay on those 2 children, and what are their ages?
117, 116. Pay $555 a month.
And that's total?
Yes, sir.
$555. Okay. Yeah. Is there anything more about your family needing you out in terms of support that you wish to add, from which you're, that you want to add to what your wife said? Is there anything more you would like to express to the court?
Yes, my kids really need me at home. My significant other need me at home. I like to be there to keep a roof over their head. I don't want to see them in the streets.
Okay. No further direct questions, Your Honor.
Mr. Sharp, Ms. Sharpless?
I don't have any questions for the defendant.
Your Honor, I don't have anything further other than argument, Your Honor. I can wait until the end of the evidence, Your Honor.
Very good. Ms. Sharpless, do you wish to call any witnesses?
Yes, Your Honor, at this time, the state is going to call Ms. Deborah Barnhill. She's the mother of the victim in this case.
Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Please proceed.
Hi there. I'm going to ask you to tell us your name and how it's spelled, please.
My name is Deborah Barnhill, Barnhill.
And Miss Barnhill, your son is a victim in this case, is that right?
Yes, my son was the victim in this case. His name is Brian Barnhill.
Miss Barnhill, can you tell us how the death of Brian has affected your family?
Quite a bit. Brian worked with my husband in the office. My husband is recovering from cancer, colon cancer, and was recovering also from heart surgery, and Brian worked in the office with his dad and provided support where I could work as a teacher, and he would take him to his doctor's appointments and things for us. So I had 2 sons, and now I have 1.
And have you and your family talked about, or have you thought about the defendant's request to have his bond reduced to a $10,000 cash or professional bond? And how do you feel about that?
I guess my greatest response is my son paid the heaviest price as his part in this crime, and I can only say it's a crime, and I no longer have him with me. So I do not think that a reduction in bond would be or should be granted.
Is there anything else about the request for the bond or about how this offense has affected your family that you want the judge to know that you haven't already said?
It affected our family financially because Brian was our youngest son. He had no children, but we'll never get a chance to have those children. He was engaged at the time, and there is no fulfillment of an engagement or grandchildren from him.
And at the time of this offense, was your son trying to recover from any issues that he had with drugs?
Yes, my son was. He was in a treatment program, and a matter of fact, had seen his doctor that day and received a prescription for treatment that day, the day of his death.
Is there anything else that you haven't said about the request for bond or about how this has affected your family that you want the judge to know?
Other than I I understand fairness, but in all fairness, I think the reduction to $10,000 is just way too low for this particular type of case and my son.
Your Honor, that's all the questions I have from Ms. Barnhill at this time.
No questions, Your Honor. Ms. Barnhill, you may step in.
Your Honor, at this time, the state does not have any other witnesses. However, it would ask the court, if it has not had the benefit of reading the arrest report already, if it would take judicial notice of the arrest report and the facts contained in it.
Court has reviewed the arrest report. We'll take judicial notice. Do you wish to make any arguments, Mr.?
Yes, Your Honor.
Medina?
I do believe that Mr. Bryant is entitled to bond, and I do believe, based on the evidence presented, that the only financially feasible bond would be a $10,000 cash professional. That would be the maximum that the family finances would support. He has significant ties to the area, not only in terms of mandated child support for to teenage children, but also to very small children who he's involved with his significant other in raising. He has two jobs that are extremely important to the family. I don't think there's any showing at all that he might be a flight risk. I do note further, Your Honor, that there has not been a motion for a pretrial detention file. Furthermore, as the court is aware, we have filed a motion to dismiss as untimely. I'm not going to try to argue it, but it is set for February 21st. And we do believe that the court is allowed to take into account other factors than the ones that I've enumerated. And one of the factors that we would ask to consider is that because that hearing is not going to take place until February 21st, that we would like to have the court please grant a reasonable bond at this point in time so he can help me prepare for the motion to dismiss based on untimeliness. There may be questions that arise pertaining to that hearing in preparation for him with respect to paperwork and whereabouts and so forth that he could assist me on. And I don't have anything further, Your Honor.
Yes, Your Honor. So, one thing Mr. Medina and I will agree on is that I do believe that he is correct that the defendant is entitled to a bond. This is not a capital case. This is not a life felony, first degree felony punishable by life. The state and the victim's family are asking for $750,000 cash for professional. In this case, I only say that because I do believe that the first appearance paperwork says no bond. And Your Honor, just to touch briefly, because again, I don't want to address that today because this is for another day. The state does intend to fight and have legal argument about the motion to dismiss for the statute of limitations. I do believe there's a good faith basis to fight that at this point in time. Your Honor, I think it's important to note that Mr. Bryant does have prior offenses on his score sheet. Those priors include trafficking in cocaine, possession of controlled substance, fleeing and attempting to elude, tampering with witnesses, and 20 other prior misdemeanors. The state does expect the evidence to show that on October 31st of 2018, the victim, who his mother has explained to the court was struggling with substance abuse and mental health issues, or substance abuse issues, did unfortunately end up contacting Mr. Bryant. It is clear from the text messages that were obtained by the Okaloosa County Sheriff's Office that a drug transaction did occur, to the effect of, do you still have that stuff? A text message later on saying, I'm here. That was an hour, and the text message from the victim to Mr. Bryant stating, I'm here, was 1 hour and 15 minutes before the victim's girlfriend, fiance, found him dead in their home. So the state does believe that it will be able to prove that Mr. Bryant sold the victim a lethal dose of drugs, and the victim's system was heroin, fentanyl, acetafentanyl, and again, it was the defendant who sold the victim, who was struggling with substance abuse issues, this lethal dose. So not only is he a danger to the community because he has had a trafficking amount of drugs in the past and has been convicted of that, at this time, on this date of the offense, he was engaged in more drug activity, and then caused the death of Mr. Barnhill. So at this time, the state is requesting that the court impose a $750,000 cash or professional bond in this case. Mr. Bryant is a danger to this community based on his criminal history and the nature of this offense. He is a danger to this community, and I don't believe that there are any conditions of bond that can be imposed that could keep him from selling another lethal dose of drugs to somebody else in this community, Your Honor. So again, the state is requesting a $750,000 cash or professional bond in this case.
Could I just touch on a couple more things, Your Honor?
Sure.
The state, again, has not filed a motion for pretrial detention. If it did, it would be required to prove beyond a reasonable doubt that Mr. Bryant should remain incarcerated. And I would respectfully contend that issues such as danger to the community, that the state would have to provide evidence of that. There has been nothing except for references to an arrest report. Issues such as danger to community in a situation where there's been no proof of anything, much less anything in the almost 4 years time since this incident. $750,000 cash or professional based on the evidence is tantamount to a denial. It's tantamount to granting a motion for pretrial detention that hasn't even been filed, much less the state carry its extremely heavy, beyond a reasonable doubt, burden of proof on that issue. Thank you.
The court is in agreement, and the state has so, I don't want to say stipulated, but has also concurred and acknowledges that there has not been a pretrial detention motion that has been filed, and therefore it is the obligation of the court in those circumstances to set a reasonable bond. There are a number of factors that are considered when you are dealing with the bond, which are enumerated in the statute. I'm not going to go over all of them. The counsel are well aware of it. The court will acknowledge, however, that this case deals with what this court feels is the scourge of our society, and that's fentanyl drugs. And so I don't believe that the $750,000 is inappropriate. And the court's granting a reasonable bond that it believes, based on the safety of the community and the severe harm that's caused not only by this but by you know, the scourge of fentanyl, which this defendant obviously has been involved in, is charged with in this case. Court's granting a $750,000.
Your Honor, may I ask for clarification?
Correct.
There are 2 counts. Does the court wish to put all of it on count 1 or split it between the counts? I just wanted to...
That's a good question. Court will have the $500,000 for the first count, which is the homicide, negligent manslaughter, and the sale or manufacture of possession of controlled substances, $250,000. That is correct.
Your Honor, I think that the next court date is currently February 13, 2023 for a pretrial conference. Excuse me, it'd probably be February 15th because he's incarcerated. So the next court date after that is the motion to dismiss on February 21st. I think at this point in time, we would like to keep him on the pretrial for February 15th, just in case there are any issues that we need to advise the court of at that point in time. And then he'll probably be coming back 6 days later for a motion to dismiss hearing. And we can, I'll discuss it with him if we want to move for a continuance of the pretrial. Okay.
Ms. Sharp, will say anything further?
No, Your Honor, that's fine with the state.
Okay. Very good. Thank you very much.
Judge.
Thank you, Your Honor.
Let's play that.